morning, everybody. Thank you so much for coming out to another City on the Move presentation. Today we have part two to protecting your assets with Medicaid with the Wilson Miller Law Firm. We have Todd Watley here. So
Thank you. All right. So my presentation is basically what is known as elder law, and that is my focus is on the aging clients, but a lot of times that involves their kids who are 50, 60 years old, 70 years old sometimes, and so the difference between this presentation and Tuesday's presentation is that Stan is a state planning lawyer, one of the nation's best, and what he does is make sure what you have at the time of your death goes where you want it to go. My job as an elder law attorney is I tend to work with people not with tons of assets. You know, my typical client, they have, not counting their house, typically $100,000, $200,000, $300,000, maybe $500,000. Okay. Well, those people, you know, my job as an elder law attorney, I do estate planning, and I'll go over that. But my job is to make sure that you have something to pass on at the time of your death. Okay. Estate planning attorneys focus on death. When you die, this goes here. I want to make sure that you have something at the time of your death. And with long-term care being home care, assisted living, nursing home, those things run, you know, anywhere from $3,000 to $10,000 a month, and that will devastate just about anyone's estate, what they have worked hard to do. So I want to go through this and just kind of recap what Stan said, but from a elder law standpoint, and then I want to spend time on how can we pay for long-term care. That's the big issue with elder law is, what if I need or my parents need long-term care? How do we pay for it? And surprisingly, you're going to learn you don't have to be broke to get it paid for by Medicaid. All right, so that's my little hook to make sure that you keep on listening to me. All right? I'm sure Stan talked about probate avoidance. The process of, at the time of your death, if there's anything that is in your name, stuck in your name at the time of your death, it has to go through probate. You don't want to go through probate in Arkansas. It is expensive, it is time consuming, and it is public knowledge. So you just don't want to go through probate. Now, please understand, a last will and testament does not avoid probate. A last will and testament actually tells the judge what to do with your stuff as you go through probate. That's court, that's lawyers, that's expenses. And the funny thing is, probate is very easy to avoid. I know Stan talked about trust, and I'll breeze by it, but I think a point that some people miss, and honestly, a lot of attorneys won't talk about this because what I'm about to tell you, the easy way to avoid probate, I make nothing from. It's like, why is a lawyer telling me to do something that he can't charge for? Because it's in your best interest, and honestly, of all of my clients, probably about 75% of all of my clients do what I'm just about to tell you. In fact, this plan that I'm about to tell you that does not involve a trust that was my mother's estate plan. I am an only child. Thankfully, she trusts me. And her estate plan was this, okay? An easy way to not go through probate is to make sure that every bank account that you have, everything that you own, has a beneficiary listed on it. On your bank accounts, you can make those payable on death to whoever that you want it to go to. Any investment accounts, make sure that it has a payable on death, or sometimes known as a transfer on death beneficiary. So at your death, they walk in to the bank, the investment company, with a death certificate, they write them a check. Boom, over with, okay? So you do that by going to the bank and telling them, I want this to be payable on death to my kids or whoever, all right? It's that easy, all right? And for your real estate, it's not quite that easy, but it's close. There are some deeds that you can do that you control your house. No one can kick you out of your house, but at your death, it then goes to whoever that you want it to go to. I caution you, I warn you, do not do a deed that completely gives your interest in this property to someone else, like a quitclaim deed or a warranty deed. Sadly, that's the Medicaid long-term care planning for a whole lot of attorneys who don't know this area of the law. They'll say, oh, you're concerned about the house, Medicaid's going to take your house, let's just give it to the kids, that'll keep Medicaid from getting it. Well, yeah, but so will these other deeds, okay? And by giving it to your kids, if they go through legal problems, you could lose your house. Same thing with your bank accounts. Don't put your kids' names on your bank accounts because it becomes their bank account. They go through bankruptcy, divorce, or a lawsuit, you've just lost your bank account. Don't add your kids to your name. Don't add their name to your bank account. You can let them be a signer and you can let them be the payable on death beneficiary, but don't put their name on there with you. Period. Okay? Now, sometimes this doesn't work. The putting your kid's name on your bank as the beneficiary, okay? So when that doesn't work is, what if your kid's really not good with money? You're going to leave them $40,000 and they're going to spend $60,000 before they put you in the ground, okay? You don't like your son-in-law or daughter-in-law, all right? It's like, I don't want them to get my money. Or they're in a high-risk profession or something like that. There are times, and if you don't want to do equal distributions to the kids, if you have 3 kids, you list 3 kids on your bank account as the payable on death beneficiary, it's going to be divided 3 ways, okay? If that's not what you want done, if you are concerned about your kid getting this money or you really don't like your in-laws, you have to do a trust, okay? And that's what Stan talked about, is a trust owns your property, so therefore you don't own anything at the time of your death. The trust owns it and it continues to go after your death, and it does what you want it to do. You know, half the money to this kid, the other half divided between these 2 kids, or 10% to your church or whatever, okay? Sometimes a trust is necessary, but most times it's not the plan that people need. My mom listed me as the beneficiary on her house, on her bank account, and her pension from work, and when she died, I submitted death certificates. It all came to me. Done, over, not a trust, very simple, and that's how most people do that, okay? Questions on that issue right now?
Are you going to talk about the type of deed necessary?
Okay. I will, yes. So there's 2 types of deeds. The preferred deed is what is known as a life estate deed. That is a deed that says, I am giving this property to my kids, but the big thing is, I reserve the right to live here for the rest of my life. So it is giving it to the kids, but the deed says it's my house while I am still alive. That was my mom's deed, okay? The problem, excuse me?
What was the
Life, L-I-F-E, estate, E-S-T-A-T-E, deed. Now there's 2 problems with that deed, okay? Number 1 is, if you ever want to move, you have to get the permission of whoever's name that you put on there and their spouse. Yeah, sometimes that's a deal killer, okay? Since you are making a gift right now, they have an interest, but it's an interest that doesn't become theirs until your death. However, if you want to sell to clearly transfer that title, they are going to have to give up that interest, which means we need their signature, and most title companies will require the spouse of that person to also sign.
Because what's theirs is theirs.
Yep.
What about commercial property?
Okay. I will get into that in just a second. When I talk about Medicaid, commercial property is a countable asset and it's treated differently for this conversation. The other deed, so to avoid those two, the second problem is since you are making a gift, and I'll talk about this more in just a second, it's a gift and therefore there is a Medicaid issue with that for the next 5 years. When you make a gift, Medicaid is entitled to know what's going on for the previous 5 years. And I'll cover that in just a second. So that's two problems. If you come into my office on a walker, oxygen, history of stroke, and Alzheimer's, I'm probably not going to do a life estate deed because we've just created a 5-year issue and you're probably not going to make it 5 years without going into some type of care. So in those situations where typically it's the man who says, I got to ask my daughter-in-law if I can sell my house. Yes, sir. I ain't doing that. Okay. Our only option then is a beneficiary deed. A beneficiary deed sounds similar, but it's different. A beneficiary deed says, if I own this house at the time of my death, it goes to these kids or whoever. Okay? So it is a revocable deed, which means if you want to move, you list your house, you sell it, you don't need their permission because it truly only comes into play at the time of your death. However, it is not protected from Medicaid. Medicaid can still put a lien on it. The previous deed that I talked about does protect your house from the Medicaid lien, and so it protects the house.
As long as there was that 5-year.
Correct. Well, sort of. I'll cover that. There's no absolute answers from a lawyer, okay? There's sort of. But yes, I'll go over that, okay?
What about a joint tenancy with right of survivorship? When that person dies, then would a lien attach to the
No,
joint tenant?
no. That's a deed that survives. My concern with that is it is owned by two people, and particularly that kid. If that kid gets sued, they can come in and take away half of your house. Not cut it in two, but the value goes to that. With the life estate deed and the beneficiary deed, the kid has no interest in that house while you're still alive, and therefore their legal problems won't affect your house. A joint tenancy deed will allow their legal problems to affect you.
Well, fortunately, I'm the other way. I'm the kid and the joint tenant's my mom.
Okay.
So
It's
it's my property.
okay. It's not the worst thing, but that is an option, but it's rarely the best option. Yes.
I would just want to ask you one thing before moving forward. I know you stated that the beneficiary, that's how your mother had you listed for all of her assets. That's how I have my daughter listed.
Okay.
But when I came to the class on Tuesday, it kind of made me question all of that. And I didn't know if doing a trust moving forward was the best option. But I personally don't have that many assets. for
Okay.
that.
How old is your daughter?
She just turned 3 yesterday.
3?
3.
Okay. So, 3.
She already has her own bank account and everything.
Okay.
So I want
Well,
to have
the problem with that is if you die, it's going to go to her and she's under 18 and she can't own anything by herself. So you've created the need for a guardianship, which is court. And
What about her father?
if you name her as the beneficiary, her father's going to have to go to court and become a guardian over his own kid to deal with this money because you left it to her alone. So I typically say a trust is not needed, but I typically deal with people who don't have minor children. Okay, so naming a non-minor child as the beneficiary works, but naming a 3-year-old as your beneficiary, that's a problem. Okay, you really should probably look at a trust. Okay, good, but that's a good question.
Yeah, I mean, because, a car wreck could happen on the next day.
Yeah, you probably should do a trust. Even though you don't have a lot of assets, the issue is you want to leave it. Can I ask just what's the issue with you and her dad?
Well, we're not married. We've both previously been married, so we kind of decided not to go that route. But
Okay.
we live together and we have her together. The house is
Okay.
When we bought the house, I was not a current working mom. I just had the baby.
Okay.
And so we didn't want to include my debt to income ratio for that house.
Sure.
So we left my name off of it.
Well, you could list him as the beneficiary, and that way but it's his money.
Yeah, I don't want that.
Okay.
I mean, you know.
You've got to do a trust. Yeah. The only way you can fix that's with the trust,
Okay.
unless you want to force them through guardianship, and you don't want to do that.
Okay.
Okay. Good question. Yes, sir.
I have one, is rental property treated like, if you have rental property, is it treated like commercial property? Okay.
As the owner of it or the renter of it?
Oh, the owner of
Yeah, it is commercial property. Yeah, and I'll go over this more, but the only thing not counted real estate wise is your home. If it's not your home, it's a countable asset, and that's a problem. Okay. Okay, so I think what is the most important document you can do, this is not a death and dying document, this is a while you're alive document, is a power of attorney. Everyone over the age of 18 needs to have a power of attorney. I've got two kids who are now 27 and 25. When they turned 18, they were at my conference table filling out power of attorney forms, because once they turned 18, they're of the age of majority, they're in a car wreck. Just because I'm their dad doesn't mean I get to go see them, okay? They won't give me information, and I can't handle their financial affairs because they're now an adult. And so every adult needs to do power of attorney, but it's crucial, absolutely crucial, once you are older, my typical client is over 65, they need to do power of attorney because the chance of them becoming incapacitated is great. Being over, if at 85, your chance of having dementia is 50%, okay? So the chances of you having dementia, having some period of time that you can't handle your affairs, if you don't do a power of attorney, we have to do a guardianship, which is a legal proceeding to take away your rights and give it to someone else. I'm not sure what Stan's beginning fee is. I know in my practice, I charge the beginning fees like $3,500. And if it's contested, it can easily go $10,000, $15,000, $20,000 for a guardianship. But signing a power of attorney now, in all but very limited circumstances, can fix that problem. Appoint someone as a power of attorney. The number one thing that I hear is, well, Todd, I don't want to give up anything. Doing a power of attorney, you do not give up anything. You just have someone out there who can help you sign things, do things. You don't give up anything. My wife right now, she is my power of attorney. I can still function, I still do stuff, but if I'm in a car wreck or if I have a stroke or whatever, fall off a ladder, then she can jump in and she can automatically do things for me, okay? Well, hang on just one second. Let me do the entire package of things that you need, then I'll tell you, okay? Did you have?
As a married person, you still.
Absolutely, absolutely. Your wife cannot, my wife cannot handle my IRA. It is in my name alone, and they will not talk to her without some documentation. That's a very, absolutely. She's not the owner, and I'm alive, and so I'm the only one who can, yeah. Absolutely. That's a very common misconception. Yes.
Does it need to be a durable power?
Absolutely. If a lawyer draws up a non-durable power of attorney other than for a very specific purpose, I want their law license. Because durable means it is good after you become incapacitated. A power of attorney, the traditional old-time power of attorney says, this person can do anything I can do, okay? Once I become incapacitated, they can't do it because I couldn't do it. Well, the whole reason of doing a power of attorney is, particularly when I become incapacitated, they can now do it. So a durable power of attorney says this is all the way up until the time of my death. Even if I become incapacitated, this person is allowed to do things for me. Okay? So you have to appoint, and married couples, 99% appoint their spouse as their agent under the power of attorney. But yeah, you start dealing with benefits, Social Security, pension benefits, IRAs, they will not talk to anyone besides the owner unless there is a very comprehensive power of attorney, financial power of attorney. Yeah, that's okay.
And I think at one point Arkansas adopted that uniform power of attorney.
They did.
You just check. But I still see the other old school power attorneys. So are they both good, or what's the story?
Okay, good question. And we do both. I do a elder law specific power of attorney that's about 25 pages long because it clearly says everything that I need it to say. The problem with that document is sometimes banks, investment places, they're like, we've not seen this before and we're going to send this to legal. That's where documents go to die, okay? And so I'm like, wait, stop. Here's the Arkansas statutory power of attorney with the check boxes. Here, take this. They're like, oh, okay, yeah, we recognize this. And under Arkansas law, they have to recognize it within 5 days. So sometimes we prefer our big fancy elder law power of attorney that clearly says everything, but when it's crunch time, sometimes just the statutory power of attorney. You'll see in just a second why under Medicaid planning, when we're planning for Medicaid, protecting your assets, we need our big, long power of attorney because it says everything this person can do to help protect your assets. Okay? So we do both. Yeah. Okay? Sure. Okay, just stop me. All right, another, and we also do healthcare power of attorney. That is your not end of life document, but the document that says, I appoint this person that if I can't make healthcare decisions, they are to make healthcare decisions for me. So we do a financial power of attorney, that's 25 pages long. Healthcare power of attorney, it's 6 or 8 pages long. But it says, yes, do everything you can to get me better, but talk to this person, and if this person can't do it, then these people, okay? We also do a living will advance directive. Yes?
Contingent, can you include a contingent on your?
Absolutely. You absolutely should. Yes, ma'am?
How many people can you put on a power of attorney, just one?
No. Well, I recommend that the current person being able to do something is one person. But just like she asked, always have a list of contingents. Because that person, particularly if it's your wife, may be in a car wreck with you, but you don't die. Now what? So yes, always do contingents. And also the attorney who does not force their client to do a contingent, I really question their skills, because it's like you've got to name a contingent. If there is no agent able to serve, there is no power of attorney, okay? And we're in guardianship court again, okay? Other questions? Okay, so a living will is your end-of-life document. That is, once I am irreversible and terminal, most people say, don't keep me alive, okay? I don't want a feeding tube, I don't want a respirator if it's simply keeping me from dying, okay? I do want one after surgery, and particularly during surgery, yes, please do that. But afterwards, if I'm not going to get better and I'm going to die sometime soon, pull that thing out and let me go, okay? That's important because if you don't put it in writing, it won't get done. Now, our document is unique because it points back to the healthcare power of attorney to be the one. What if one doctor says you're irreversible and terminal, but the other doctor says you're not? Now there's a conflict. Who wins? Well, typically they're going to keep you alive if there is some doctor saying, I think we can do something to keep her alive. In that situation, the healthcare power of attorney has the authority to make that decision, to say, I'm going with this doctor. Whichever one that is, they get to choose, yes, keep you alive, or no, you don't, but it's someone who loves you and can look at the situation and say, yeah, this is what's going to be done, okay? And then finally, a missing document is the HIPAA release. The Health Insurance Portability and Accountability Act is your healthcare privacy law. Without a signed authorization to talk to all of these people, your healthcare people will not talk to anyone. So you have to file this or get this signed, have it with your documents, and this is the one document that I highly recommend that my client give to those people. They're the one that's going to need it. You're not going to need this form. They're going to need this form. So give it to them. So if you're in a car wreck in California and you go into their hospital unconscious, they fly out there and say, how's mom doing? How's dad doing? They're like, sorry, we can't talk to you. They did not sign a HIPAA release. They're like, ta-da, here it is. Okay? So that gets them information.
So that HIPAA release would come through an attorney, not?
Well, I recommend it, yes. It is part of our documents.
But your
The reason why I'm asking this is because when you go to your doctor,
Uh-huh.
they have you.
That's fine. Yes. Okay, good question. Yes. Keep signing that form if you can. This form comes up in the example that I gave. You're in California on vacation, you're in a car wreck, you're unconscious, you go into their hospital unconscious and you can't sign their forms. Your family shows up. Without this form, they're not going to talk to them, or they shouldn't talk to them. So this form gets you through that California hospital door to say, give me information on mom. Yeah. So all of those documents, financial power of attorney, healthcare, and there's two financials, just like we talked about. One healthcare, one living will, and one HIPAA release. For all of those documents, we charge $750. That's what I charge. I think that's okay.
I don't do any little,
Okay. And then for a couple, it's not quite twice the work, but it's not just one. Typically, we charge $1,250 for that. So, a lot of my clients come into me thinking they're going to spend $3,000, $4,000, $5,000. All they need is powers of attorney, either a life estate deed or a beneficiary deed. And then I tell them, go to your banks and do POD. So, and for a deed, typically with other things, we charge $250. So for $1,500, they are completely fixed up and done. Okay? Unless you need a trust. Okay, and that's more. Yes?
do you not always, though, just do a simple will too? Because, if someone's killed in a car accident, that, and then there's gonna be a claim against
Very
them.
good.
I mean, that could be a lot of money. That's not gonna be part of any of that. It's gonna be part of your estate. If you want to have say in where that goes, you would need a will.
Correct. But the state of Arkansas has a will for you that in most situations makes sense. If they want to do something that does not follow the Arkansas law of intestate probate, yes, we do a will to say, I am not including this child in my estate. Particularly if you're disinheriting a child, yes, you probably should do a will with those documents just in case something does go through probate, which a lawsuit would have to go through probate to do that.
Yeah, so anything, I mean, even if it's not, what was I gonna say, even if it's not something that you're anticipating, having a will in those cases wouldn't be any more of a burden because probate is the same whether you have a will or not.
Correct.
It's just sometimes you don't have to do it at all, right?
Right. All of my clients hopefully don't have to do probate at all. But there are situations where things can happen, and if they want to do a different distribution than the state of Arkansas lays out for them in law, yes, we will do a will.
I guess I'm always thinking if I just get killed in some random accident, might as well get a good payout.
Might as well, yep. Okay, so now that's phase one. Hopefully clients come to see me while they have capacity, they can sign documents, and we get them fixed up. Every client, I can say, every client needs to do powers of attorney. So now we're set up for when the next phase is, and that's when, what if you need long-term care, okay? You typically, your family comes in to say, hey, mom's had a stroke, she's in the hospital, they say she's probably not coming home. We checked out nursing homes and they're $6,000 a month. Oh my God, what do we do? Okay, that's when the other folks, typically it's clients, but even non-clients, that's when they come to see us. And I've listed all the prices that are fairly current right now. One benefit is VA benefits, okay? Now, I want to go through that real quick just because that is a great service that can help pay, it's a great benefit to help pay for long-term care if you qualify. So, this is for a veteran or a widow of a veteran who needs care. The veteran had to have served 90 days active duty. Reserve doesn't work, okay? Has to be active duty. One of those days has to be during a time of war. So there are war dates for World War II, Korea, Vietnam, Iraq, okay? They have to have served one day during a time of war, and now they are either 65 or they have a disability, and the disability does not have to be connected to their service. That's the huge misconception. A lot of our clients who get this benefit, we have to overcome the issue of them saying, I was not injured, and as a non-injured veteran, I get no benefits. That is incorrect. This benefit is for veterans who got out of the service completely uninjured, thank God, but now they have Alzheimer's, a fractured hip, whatever, it doesn't matter as long as they have a disability that requires them to need care, all right? So, and the disability is defined as needing assistance with at least 2 activities of daily living. Bathing, dressing, walking, feeding, going to the bathroom, getting a shower, whatever. Those are ADLs. If they need assistance, then we can get a married veteran who meets those qualifications. We can get him $21.69 a month for a, wait, that's not right. Scratch that. Where did that number come from? I'm sure I typed that in there.
Was it late at night when you did it?
It was late yesterday. So the married veteran is the $22.30. Sorry about that. The single veteran is about $1,800. Okay? And the widow of a veteran is just over $1,200. Okay? So, 9 days active duty, 1 day during a time of war, now needs ADLs. They do look at assets. Don't let the VA tell you, oh, you've got too many assets, you don't qualify. That could technically be true, but there's some creative ways we can arrange the assets so that it falls within their calculations, okay? And this is tax-free money, okay? This money goes into your bank account and you can pay for home care, assisted living, or nursing homes. All right? So you don't have to go into a VA accredited home or facility. It's wherever you're going and you're spending money on healthcare things, the VA, if you meet these qualifications, will come in and pay you that much money. Okay?
And what's that program called?
Aid in attendance. It's the technical name is improved pension, but everybody knows it as aid and attendance. It's a pretty cool benefit. All right, so now let's talk about Medicaid, okay, where the real, everybody can qualify for Medicaid, basically. What you need to understand is Medicaid is a federal program, but it is run by the state. So Medicaid in Arkansas is different than Medicaid in Oklahoma, and that's different than Medicaid in Missouri. Okay, so if you've got someone who lives in another state and they're on Medicaid, and it's like, well, this is what they did to qualify, great, but that may or may not be true in Arkansas. So understand, Arkansas every state is very specific. Medicaid's going to look at your assets as the person applying for Medicaid. They're also going to look at your spouse's assets. So if you're married, they're going to look at their assets. They don't care if you've been married 6 months or 60 years. They're going to look at your assets. Now, of all of those assets, there are times that I run out of money, we'll take 5 acres, list it, sell it, I get the money, pay for my care. And it was not her home, okay? She lived somewhere else. And I said, well, that could be true. Let me look at the deed because there's some exemptions in there. So they got me the deed, and it was joint owners with rights of survivorship between her and her siblings. I was like, stop. Send this to DHS, tell them under this policy number, this is a non-countable asset. And the nursing home was like, Todd, you have lost your mind. I said, just do it. Just do it. And so they're like, okay. And so they sent the deed with policy number so-and-so says this is not counted, sent it in, boom, she was on Medicaid. They did not have to keep selling the family farm. It's just because you recognize the deed and it's like, this is not counted. DHS, I'm assuming DHS was never told that. Now, there's been times when they're like, oh, you own this farm and it's not your home, you're disqualified. They don't go any further until I make them look at it and quote the policy to say, yeah, this is not counted. So, yeah, so there are situations like that. So a inaccessible asset that she could not by herself convert into cash was not counted. Arkansas is an income cap state, meaning that you cannot make over $2313 and qualify for Medicaid. But Todd, you just said nursing homes are $5,000, $6,000, $7,000 a month. How do I pay for it? If I'm totally broke and my income is $2,400 a month, how do I pay for the nursing home? Well, that's a good question. And Mr. Miller in Colorado went to court many years ago and said, Judge, here's my situation. Colorado says I make too much income for the nursing home, but I can't pay for the nursing home and I'm broke. What do I do? So now there is this thing known as a Miller Trust. Don't worry about it right now. You only do it at the time that you need care, and it's where your income goes in. It's an irrevocable income trust, so therefore, once your income goes in, you don't benefit from it anymore, and your income is zero, you now qualify for Medicaid. That money goes to the nursing home, but you're now on Medicaid. So if someone says, oh, your income's way too high, you won't qualify, just say, that's fine. We'll take care of it later, okay? A Miller Trust will fix that. Okay? So if I can only have $2,000, I'll just give everything away, okay? This is America, you can do that. But there is a 60-month look back with Medicaid. So when you apply, you are supposed to tell them, and they can go look for the previous 5 years to see, have you given anything away? If you have, then they put it through what is known as the gifting penalty formula. That formula is basically the amount of the gift divided by the average cost of nursing home care in Arkansas equals the length of time they will not pay for the nursing home. Okay? Example, $58,000. If you give away $58,000, the average nursing home this year is $5,749, so that's almost $5,800. So a $58,000 gift, had you not given it away, would have paid for 10 months worth of care, so therefore Medicaid will not pay for 10 months. It's that simple. People come to me all the time saying, Todd, Mom gave away $58,000 a year ago, so we've got to wait 4 more years until we can apply for Medicaid? No. Get her qualified, apply for Medicaid, start the penalty. We can get her on Medicaid in 11 months because there's a 10-month penalty. After we serve the penalty, we can get her on Medicaid. So don't think just because there's been a gift, you can't go on Medicaid until the end of 5 years. Now, if you give away $580,000, yeah, that's a 100-month penalty. You need to wait till 61 months to apply, okay? But with smaller gifts, we can get you on Medicaid during the 60-month look back. Now, when does the 10 months start? That's the issue. Under the old rules, when I say old rules, prior to 2006, the old rules were when the gift was made, that's when the penalty started. So you give away $58,000 today, 11 months from now, you're fine. That's the old rules. They stopped us from doing that because that was very beneficial. In 2006, they changed the rules so that the penalty starts when 3 things are in place. Number 1, the person is in a Medicaid facility, being a nursing home or a assisted living that takes Medicaid. The person is otherwise qualified for Medicaid, meaning they're broke, and they apply. So here's the situation, okay? Grandma gives granddaughter, let's say $58,000, okay, for college. A year later, and grandma still has, say, $116,000. A year later, grandma has a stroke, goes in to the hospital, she goes into the nursing home under rehab, she doesn't make good progress, and she stays there. So now she spends her $116,000 until she's broke, and then, so she's in a nursing home, she's broke, and she applies for Medicaid. Now it's 3 years later, 4 years later, she applies, and they're like, oh, within 5 years ago, you gave away $58,000, you're disqualified for another 10 months. Well, who's going to pay for that? She's broke. Guarantee you the granddaughter ain't got the money, okay? It's on sorority parties and God knows what, so it's gone. Now what? Someone's got to get the money out of their pocket to pay for grandma's care, or she's coming home with somebody. However, had she come to see me, and I'll cover that in just a second, okay? So just to understand, the penalty starts when you're in a nursing home, broke, and apply. So keep that in mind. My absolute favorite client is the married person who's having to put their spouse into a nursing home. Typically, it's a female. She's heard from, and I love all these places. I'm not talking disparagingly. I'm just not saying this is where you should get your legal advice, but from church and beauty shops, okay? Church and beauty shops, there's a lot of legal advice handed out there. And so she's heard from the church and beauty shop, I'm going to lose my house, all of his income goes to the nursing home, and I can only have $2,000 because Mildred's cousin's husband got sick, and that's what they did, and I know that's what's going to happen to me. Hopefully someone gets to this lady and says, go see Todd. Sit down with Todd, let him explain this to her. There's a whole section of the Medicaid rules called the spousal protection rules, meaning that the spouse of someone who has to go into a nursing home does not have to be broke. Listen to me, okay? I can use those rules to protect a married couple with $400,000, $500,000, $600,000 plus their house, get him on Medicaid, and she loses very little money, okay? How we do that is when he goes into the nursing home on that first day, that is known as a snapshot date. So on this date, they have, let's say, $200,000, not counting those things on the list, house, household furnishings, vehicle, those things. $200,000. She gets $100,000, he gets $100,000. Her $100,000 is protected. She gets to do anything she wants to with that other than give it away. His $100,000, that's what's got to be spent down to below $2,000. Okay? How do we spend $98,000? Well, you can spend it on the nursing home if you want to, but we can also spend it on this list of things over here. That's why I put this in here. We can take his $98,000. Number one, let's look at the house. What if she has a $98,000 mortgage on her house? One check and he's done. We write $98,000, pay off the mortgage, he's under $2,000, he now qualifies. That quick. Okay, what if the house is paid for? We take $98,000 and say, okay, does the house need any work done on it? Does it need siding, windows, roof, floor, plumbing, electrical, trees out of the backyard, fencing, you name it, we've done it. Even bought a big old fancy hot tub for the back porch one time. I was like, I don't know that this is going to go through, but went right through, okay? Get the house fixed up so that the wife living there can have a nice house. The vehicle, how old is your car? Well, it's 10 years old. Let's get a new car. Trade that one in, buy a new one. We're using his money. Please understand, after he's in the nursing home. So many times we get phone calls and they say, Todd, my husband has just gone to the nursing home. They told me it's going to be $6,000 a month. I guess it's too late. No, this is the time we can do something. We can't do anything before he goes in unless we're 5 years before. We can do something now that he's in the nursing home. Now's the time we get to work. All right, so yeah, come in, let us help you. A new vehicle, how's your washer and dryer, refrigerator, anything in this house, dining room table, bed, dresser, living room, whatever, go buy new house stuff. Medicaid's okay with that. And then for sure, let's make sure that your burial's paid for. And surprisingly, Medicaid lets us pay for her burial and his. So there's $10,000 or $15,000 right there, okay? So a lot of times, if we've just got to spend $98,000, we can do that extremely quickly. Now, you said, Todd, we could do higher amounts. Okay, so at $300,000, it's not $150,000 and $150,000. Sadly, Medicaid forces the spouse, all she can keep is about $127,000. That's the max. So with $300,000, she keeps $127,000. Whatever the rest of it is goes over here, okay? More than $127,000. It goes over there, but still we can spend it on these things. You start getting up to $500,000 or $600,000, she is still there at $127,000. A big amount goes over here. And interesting thing is, Medicaid doesn't like this rule, but federal law forces them to do it, and the state of Arkansas is under an injunction to require them to let us do this. What this is any money that we can't spend on the home, vehicle, household furnishings, we can put into a very specific annuity. It converts it from an asset to income to the wife. She gets to keep everything. So with $500,000 or $600,000, get the house fixed up, new car, burial, all of that stuff, and then convert it into income back to her. She gets to keep everything. Ta-da. Okay. So that's why I beg people, please come see me. Well, what I just said is, okay, but a version of that is wherever, okay? Other than California. California has not even passed Medicaid law that was done in the mid-'80s. It's crazy, okay? So, for a single person, all right, it's not as creative. I can't protect everything, but I can protect some. So let's go back to our previous example. Grandma with the gift goes into the nursing home, spends her money. Essentially, and if I had a whiteboard, I could explain this better, but just kind of go with me. So for a single person, I can protect half of everything. How we do that is, so if, let's just use $5,000 as the divisor because that's a nice round number. She comes in, Grandma goes into the nursing home, and let's just play like there were no gifts, okay? She goes in, family comes to see me, and there's $100,000 in her bank account, okay? It's okay. So $100,000, they come to see me. If I give away the whole $100,000, that means we're at $5,000 a month, we're under a 20-month penalty. Well, 20 months will eat up the entire $100,000. So what we can do is we can take half of that money, $50,000, give it to the kids. That's a gift. Divided by $5,000 a month, that's a 10-month penalty. We take the other 50 because we can't apply, or the penalty doesn't start until she's broke. We take the other 50, put it in that annuity that I just talked about. It converts it from an asset to income, and we have that pay out $5,000 a month for the next 10 months. So now we're using her money to pay for the penalty for this gift. Now let's go back to grandma with the $50,000 gift to her granddaughter. She goes in the hospital, let's say we are to the nursing home with $50,000. She spends her 50, she's broke, she's in a nursing home, and she applies. Now there's that $50,000 gift that she's just qualified for 10 more months. Had they come to see me, I would have taken the 50, not paid it to the nursing home just directly, put it in the annuity, and then pay the nursing home. Boom. We've used her money to pay for the older gift. She gets to stay there where she needs to be. The family doesn't have to pay for the nursing home, or they don't have to bring her home because no one wants to do that. All right? So I beg people, please come see me, okay? Let me help you through this situation because there's some pretty clever things we can do to make sure you don't have to be broke to go into the nursing home or pay money out of someone else's pocket to pay for some previous gifts. Particularly if there are previous gifts that you can't get back, you got to come see us because that way I can use your current money to pay for those gifts. Okay.
POD that you talked about in a checking account, can you do more than one person?
Sure. Yeah, that's what I was saying. If you do more than one person, the distribution is going to be equal to those people. And that's where if you want to do unequal distributions, that forces you back into a trust. With a trust, we can do pretty much anything that you want to, but it's just way more expensive. Sorry. Okay?
So your only location is Bentonville and Rogers?
Well, that's where I am. Wilson Miller's here, basically right across the street.
Yeah.
Yeah.
Our home office is in the Regions building, and then we have an office in West Little Rock and Northwest Arkansas.
I'm a consultant for them. They do elder law. I mean, they do estate planning. I do elder law, and so they consult with me to do. I drove down from Bentonville this morning to give this presentation because for some reason, this is just my thing. This is what I do, and I love it. So, yeah. Yes?
The two deeds that you talked about, would they cover commercial property?
Well, they will, but it will be the interest that you retain in a life estate deed goes against that $2,000. So with commercial property, you need to do one of two things. Either just completely give it to whoever that you want it to go to, or do a irrevocable trust, okay? And that scares people, and I could talk an hour just on irrevocable trust, but that gets it out of your name. But with this trust, we can preserve all of the IRS tax provisions, the good things for owning property, but it's not in your name and it's not counted against you for Medicaid, but you have to make it 5 years, okay? Yeah. Same thing with rentals, yeah. Okay? Other questions?
A simple question is for our.
There are no
city
simple
employees.
questions. Okay.
When I've had this come up several times, one of our employees passes away.
Mhm.
And their girlfriend, brother, dad, uncle, whoever comes up and wants to get their last check.
Yeah.
And I say, can't give you a last check because, we, it's part of his estate now.
Mhm.
I never understand if they have power of attorney, why can't they get it, blah, blah, blah. I say, hey, you have to go file for a small estate. If you do that, bring that back, you can do it. But then everyone thinks it's ridiculous that I'm requiring that. So what do they need to do so that whoever they want to can get this check? Because it becomes a big issue.
Well, pretty much exactly what you just said.
Okay.
Remind people, powers of attorney die when the person dies. It can only go up until your last breath. And number two, that last check, thankfully Arkansas does what's known as a affidavit for collection of a small estate. If your probate estate is $100,000 or less, it's a pretty simple form. You can just download it, fill it out. I think for $25 you file it at the courthouse, and in that document it tells who they are appointing to get the check. And so your advice is spot on.
Okay. Because no one ever likes that advice. If, I don't know why.
Welcome to my life.
If we had, because people think their beneficiary that they put on their life insurance is gonna get off in a
Yeah.
case. If they sign a form, just like what they do when they name their beneficiary that says, anything owed from the city that's owed to me shall go to X, would that be a reasonable solution? Or is that
That's not
a
legal.
whole nother can of worms?
That's
Okay.
not legal.
Okay.
The thing about the affidavit for collection of a small estate, it's a filed document, filed so the entire world can see. So if it does say, say the employee has 3 kids, one's here local, one's in California, one's in New York. So this kid comes and it's like, hey, just for convenience, I'm gonna list my name as the one who can do this. They bring it to you, you give them the check. Your liability is now done based on this legal document. If these 2 kids call you saying, wait, I should have got a third of that. She's got 3 kids and you gave it all to this kid. It's like, hey, that's a legal document. Go hire a lawyer to fight this document rather than you getting in trouble to say, I guess we should pay them that third. So there is nothing you can do really.
Okay, I just hate being the bad guy.
I know. Hey, welcome to my life.
Okay, okay.
All right? Did you learn something?
Yes.
Okay, good. So